Many thanks to the distinguished members of the delegation of Cambodia for their replies. Indeed, it was a good system of replying one by one questions, but still remains some points to clarify, and I wanted also to appreciate the fact that you mentioned, Your Excellency, the Chair of the Delegation, that you reply to questions with sincerity, and I would like to reply with the same openness to you as well. To go back to the rationale or the spirit of this exercise, we are a group of 10 experts of the Convention. We know the Convention and would like to help you to better understand it. You are experts of your own legislation and you'll help us to understand where are the meeting points of your legislation with the Convention and where are those points that remain still uncovered. So this exercise is done in good faith that we understand better each other and also for the benefit of your citizens that they are fully protected from enforced disappearance, as everywhere where this convention is ratified, we are going to make some more detailed comments maybe or further questions in order to clarify everything. And I will try to make the same methodology of trying to go one by one to your replies. I understand there has been no consultation with civil society for this report, and I would like to understand, is this a lack of interest? Although I understand there is an app which is specific for engaging civil society. Is this a lack of interest from civil society for this particular convention? Then would come to the raising awareness about the convention. Tomorrow maybe about the training and everything that is linked with that. Or is this a general stance that you see also for other reports that you prepare for treaty bodies according to the obligations that you have for reporting to the UN system? The second point is about the draft on the human rights institution. Yes, it is impressive, the number of consultations, 32 and even more, but I would like to be precise. Do you foresee a date when you see that the law can be approved? You know, of course, this is a legislative process. You cannot have control over it, but more or less, you know the procedures, how long they take place, and from where they go to the committees within the parliament, maybe until the entry into force of this law. I would like very much to know if there is any kind of indication around the specific time when happily we can see this law be into force, and after that also to understand a little bit the support that the state will give in terms of supporting this new institution financially with human resources to fully exercise its competencies. But this is in the second phase. First one, which is the time that you foresee for the entry into force of it. No statistical information. We take note of that, but still I think that there is need for more attention to this point, because it's not that we are speaking about the cases actually. This system is based, this convention is based on a system of prevention and fighting impunity, which are two pillars that are quite important. So no cases, you say. We have few urgent actions, so we are not matching indeed our both realities, your reality with ours, what we have in our files. But still, also I mentioned the fact of previous human rights abuses, so that's important as well. Do you have any data? For example, how many cases of enforced disappearance have occurred during the Khmer Rouge regime? Is this any kind of this data that you can share with us? Acceptance of Articles 31 and 32. Yes, we understand that there is a process within. Who is the last instance that decides? Because I see that there is no discussion at all. I would like to understand who is the last instance that decides for accepting the competencies under these articles. Is Ministry of Foreign Affairs? Is Council of Ministers? Is Parliament? So we'd like to know a little bit more on the procedure that you should follow. And of course, with due respect, we respect your sovereignty and your actions that you are taking. But when we are speaking also in other cases, when appropriate, this is very huge. when appropriate, it can be tomorrow, it can be after 1 year, it can be after 10 years. So if we can be more concrete, that would be appreciated. Take note also that there is no explicit provision, and also take note of the fact that no cases of emergency, or in practice, both laws, even the Constitution, but also law on state of emergency has not been applied yet. So no, even in the pandemic situation, it was not applied. But still, we're just reiterating the concern that have been raised, and you know it very well from the Human Rights Committee, about the wide competencies of the government. So let's put it like that. It's good that in practice we don't have any kind of concern, but the concern starts from the law itself. So if the law itself raises concern, that imagine what can happen in practice. That's why I wanted as well to raise this point, that if you have any kind of reaction of what other committees have raised regarding this particular element. A crucial point, the fact of autonomous offense of enforced disappearance. We understand very well that different situations in different countries may react or may have different reaction from authorities. But there are two different situations I would like to emphasize. The fact that you have reacted or thought about it with the ratification of a convention, the first question that should come to the mind of authorities is, do we need to make any specific law to implement this convention? And if there is any kind of practical problem with that, we can understand, we want to support you. But when you come to us and you say, no, there is no need to have a specific article, because this is covered by different articles in our criminal law, then we have to stop and to think it twice, because this is going, or this is a question, a debate that goes to the heart of the convention. If there was enough to foresee and to punish enforced disappearance with different elements in criminal law, then someone can come to the conclusion that there is no need for the convention at all. But it was the contrary. When the convention was written, it was said that this specific type of elements that are separate does not cover fully the seriousity and the type of crime that enforced disappearance presents. That's why we all the time repeat it. If you may maybe have the occasion to see other concluding observations that we have done for other, there is need. The position of the committee is that there is a need for that. And that these are all elements that, of course, the committee as a whole will discuss. And I hope very much that when we write down some concluding observation, you will take them with the same spirit of sincerity and goodwill to understand better why we can put some recommendations that are really important for the implementation of the convention. Mitigating circumstances, of course, there are, and it's good that you have foreseen in your criminal law, but there are some which are not coinciding with what the convention is telling. And I'll put only one element. For example, the disappearance of a pregnant woman is an aggravating circumstance. Why? Because it can bring also to the disappearance of the child, to illegal adoption, to conceal the identity of the child. So it's a chain reaction of other, let's put it like that, crimes. That's why it's important that aggravating and mitigating circumstances are provided within the concept of enforced disappearance. Of course, you can argue that without the law that puts an autonomous crime of enforced disappearance, it's not possible. But I wanted to explain a little bit situation where this is indeed very much needed. Responsibility of the superiors. Of course, I took note also of the doctrine that you have in your criminal code, but the specific article in our convention puts two different situations. First, when the superior gives illegal orders, and this can be punishable according to one of your criminal provisions, The other one, which I believe still remains uncovered and needs some clarification, is what happens if the superior has the obligation to exercise its full competencies over someone who is under his orders and does not exercise this function to prohibit acts of enforced disappearance. So it's not only by ordering that you are complicing with this crime, it's also by negligence, by, let's say, lack of putting the authority to stop crimes of enforced disappearance from persons that are under the authority of the superior. Minimum and maximum sentences. I apologize, but I did not understand exactly the reply, because what I was asking at the beginning was to give me some examples. For it's 5, it's 15, it's 7, it's 8. You mentioned that for crimes against humanity, it's life sentences. We agree with that, but I was asking about acts of enforced disappearance as individual crime, not when they are under category of crimes against humanity and war crimes. Statute of limitations, yes, you have catch it right, the concern of the committee, and still I need to say that this is very important. And my concrete question will be, who stops the statute of limitation? That you tell us that it happens when there is an accusation or investigation. But if it does not happen, what does it mean? For example, if 15 years have already passed without an investigation or without a complaint, and then it comes out that we are facing a case of enforced disappearance, is it prescribed? Is there a possibility to start investigation on this case or not? Another and last question. You mentioned gendarmerie, and I suppose you are talking about military. So that means that military has the right, because your answer was yes, but still I want a kind of reflection here, because we have a statement in our committee that says that enforced disappearance should not be judged by military courts, because there is this risk of human rights respect on that. Maybe you will have more time to see on that statement, because it's really guiding on that case. And the last questions that I have, it's still the same one, which is quite simple. Can an investigation start for an alleged case of enforced disappearance without complaint? And I take also some indication from some reports of civil society where there was this case of Thai activists where someone from authorities came out and said, no, we have not registered anything because we have no complaint. But everyone was talking about this case, so I suppose that there should be some basis on which the investigation should start, and the convention is clear enough when it says that the complaint is not a condition for starting an investigation on alleged cases of enforced disappearance. And I think that for today, this is what I had. I thank you again for your replies. And maybe, I don't know, some questions posed by my colleague Barbara were not replied. Maybe you take also time to have a few minutes on that. Thank you.
Merci beaucoup.
Thank you very much, Ms. Janina. I give the floor to Ms. Lochbihler.
I would encourage you to come back to my answers at the beginning, and maybe I connect an additional question to it. When asking how you build capacity to create comprehensive search mechanisms, for example, I would also like to ask what technical capacities do you have in Cambodia to establish a genetic database, for example? That's a new additional question. Now, on impartiality of the judiciary, you referred that you have established an anti-corruption unit and you have an anti-corruption law. Now, in the report of the Special Rapporteur on Cambodia from last year, again, as he did in his report in 2019, there is, again, the criticism that there's a lack of transparency in the judiciary, and there also is a need to tackle corruption, which seems to be very widespread. So if you could refer to some examples, in addition what you have said, how you tackled and how you made a special effort to tackle corruption and the lack of transparency in the judiciary. Do I have more time? Okay, then I will take one coming back to the answer on the consultations with the civil society. So I understand that you had no direct consultation, and that is under the working group on the Human Rights Committee of Cambodia. Now, if I look into the situation of the civil society working on human rights as such in Cambodia, I come across the common statement of nearly all UN experts from November 2021, when they went public to highlight the increasing difficulties of human rights defenders and human rights NGOs who work on different human rights violations, but also on enforced disappearances. And so my question is, following up this statement, what measures have you taken or do you intend to take to re-establish an environment respectful of the rights of the civil society? And in particular, do you intend to revise the law on associations and non-governmental organizations, which we have been, I think it's a recommendation out of the UPR from 2019? Thank you.
Merci beaucoup.
Thank you very much. Ms. Lochbihler, I see 4 nameplates are up for questions from the rest of the committee. I'll begin by giving the floor to Mr. Mata Diop. You have the floor.
Merci, Monsieur.
Thank you, Chair. I would also like, if you'll permit me, to take this opportunity to thank the delegation for participating in this exchange, this constructive dialogue with the committee. If we accept the theory that there are no enforced disappearances in Cambodia, nonetheless Article 3 of the Convention compels state parties to investigate all forms of disappearance that take place in the country, including disappearances perpetrated by non-state actors. When talking about enforced disappearance, we presume the involvement of the state or state agents. And that's why it's so important that we have statistics, data, so that we can identify cases of disappearance writ large, involuntary or not, including absences or missing persons under suspicious circumstances. So I'm a little bit puzzled by this blunt answer that there are no enforced disappearances, but that there is no register of disappearances, which could be involuntary or suspicious, particularly given that Article 2 of the Convention calls for data to be maintained. So I'd like to ask, is there a database somewhere which measures this key element of the Convention, investigations into suspicious involuntary disappearances? Are information along those lines held somewhere? And in such instances of involuntary suspicious disappearances, what processes are in place to investigate said disappearances? Thank you very much. Thank you, Mr. Diop. Says the Chair. I give the floor to Ms. Carmen Rosa Villa-Quintana. Thank you very much, Chair. Given that this is the first time I'm taking the floor, I'd like to welcome the Cambodian delegation and thank them for their overview of the situation in Cambodia. I just want to make sure you're all following the interpretation. Now, according to what we heard from you or read from you in paragraph 10 of your replies to the list of issues, you state that under Article 31 of the Constitution of the Kingdom of Cambodia, the Constitution is the supreme law, but all laws that are still enforced, the international laws that the Kingdom of Cambodia is a party to, are recognized. Against that backdrop, I'd like to ask what prevents you from defining enforced disappearance as a standalone or autonomous crime. We welcome the fact that you have recognized it as a crime against humanity, but I fail to understand what prevents the state party from aligning its domestic legislation with the provisions of international treaties? Why the supremacy of the Constitution prevents that? Particularly given the long-standing jurisprudence that we have seen in this committee and we would invite you to read that jurisprudence that speaks to the importance the committee attaches to ensuring that enforced disappearance or disappearance is defined as an autonomous or standalone crime and is understood as a continuous crime. Now, I make this point linked to a point that's been flagged here as well, and that is the issue of the statute of limitations, because according to Article 8 of the Convention, Paragraph 2 thereof, the state party shall guarantee the right of victims of enforced disappearance to have an effective remedy during the term of limitation. But in 1B, we read that this commences from the moment when the offence of enforced disappearance ceases, taking into account its continuous nature. Now, you explained to us that, as in many countries, this is suspended, as with many other crimes, whenever there is an accusation or investigation, and that's the approach that you follow. But here I echo the concern raised by the rapporteur, to wit that many of these cases only come to light years after they occurred. More than 5 years may have elapsed. We have come across circumstances or cases of enforced disappearance when 10 years have elapsed before the case comes to light. What this means essentially is opening the door to impunity. And it would be a contradiction of the Convention and its preamble when it underscores the importance of tackling and eradicating impunity for the crime of enforced disappearance. I would also point to something that you flagged in stating that there are no enforced disappearance, and that therefore, should a disappearance occur, you use other parts of criminal law to investigate and prosecute same. But I still do not understand why you cannot domesticate the provisions of Article 2 of the Convention, responsibility of law enforcement officials, refusal to provide information, etc. And that these steps may have occurred and therefore a person may have fallen outside the protection of the law. Now, enforced disappearance is a crime against humanity. That needs to be duly recognised. I thank you that you've alluded to it. But I think the major concern we have is the failure to align Cambodian domestic legislation with the provisions of the Convention. And that's what I've sought to illustrate. I would welcome more information from you about the Supreme Council of the Judiciary and the composition of this Supreme Council and the composition of the judiciary, and thank you for all that you've already shared along those lines. But I would like to ask what the processes are for the appointment of judges and prosecutors. How do you guarantee the suitability of those who are seeking judicial appointment? How do you guarantee that they are impartial and independent in their actions? Particularly in light of a point that has been raised about suspicions or concerns about levels of corruption in the judiciary. Although, of course, it is true that there are 3 different pillars that have been mentioned here: education, prevention, and application of the law. I would nonetheless like to ask, when judges are cited for corruption, who investigates them? The independent body that you referred to? The judiciary themselves? How do you guarantee that an investigation into acts committed by judges or prosecutors, including corruption, is carried out impartially and independently, and in such a way that we can be sure that there is no back scratching within the judiciary, a sort of turning a blind eye to the actions of one judge by another? With regard to the participation of the judicial police and the Royal Gendarmerie, on the basis of the explanations that you have provided us with, it would seem that this is an inquisitional process. There's an investigating or instructing judge who spearheads the investigation, and that same judge shall determine the circumstances of the case and the definition of the type of crime in the case. I'd like to ask, what is the role played by prosecutors within that process? Secondly, I'd like to ask what happens if a judge decides to dismiss a case and not to take it forward. Is there another avenue open to overturn such a decision? Can such a decision be appealed? What is the jurisdictional body which takes decisions if a potential case of enforced disappearance is dismissed by a judge? Bearing in mind your claim that this does not exist in Cambodia, but hypothetically, were it to exist, what would happen? Because you yourself alluded to cases that might equate to disappearance if not enforced disappearance. So I'd like to know what happens in such circumstances. Thank you very much, and I look forward with a great deal of interest to your replies and your clarification of the points I've just raised. Thank you very much. Thank you. Says the Chair, I give the floor to Mr. Mohammed Ayat. I would like to echo my colleagues and the Chair in welcoming the Cambodian delegation. Thank you for having travelled to Geneva for this very important interactive dialogue. I noted that the Constitution of the Kingdom of Cambodia explicitly recognises international law and international norms and standards and their importance, particularly international human rights standards. Reference is made to the Universal Declaration on Human Rights in your constitution and other international human rights conventions, if I understand you correctly. Reference was also made, again, if I understood you correctly, to the fact that the Kingdom of Cambodia has ratified 8 UN human rights treaties, 8 of the 9. The human rights treaties represent a single robust system. And bearing in mind that the Convention on Enforced Disappearances is the most recent of the United Nations human rights treaties, I am curious to know which is the UN Human Rights Treaty that you haven't ratified, that 9th treaty, and what prevents you from ratifying the one human rights treaty that you haven't ratified. My second question is about the criminal responsibility of superior officers' hierarchical responsibility, but I haven't quite understood where the division of responsibility or accountability stands between an order given by a hierarchical superior and it being carried out by a junior official. Now, of course, as you understand, the order of a hierarchical superior can never be used as a pretext, and that must be duly spelled out in the legislation and enacting regulation of a state party to the convention. Finally, the definition of an autonomous or standalone crime, having defining in the criminal legislation enforced disappearance as an autonomous or standalone crime, is an obligation under the convention, an obligation. My colleague Ms. Yanina used 2 arguments to underscore the importance of including enforced disappearance as a standalone autonomous crime in your legal arsenal. First, she made it clear that no other violation or crime can be equated to enforced disappearance. Second argument that she advanced is that defining enforced disappearance under the heading of any other criminal activity would not reflect the seriousness or gravity of enforced disappearance. It cannot be equated to another crime. It's a separate crime. By way of illustration, I would point to the crime of genocide, something with which I am familiar. In Cambodia, there was, at a certain point in your history, a genocide And I would respectfully submit that murder, assassination, any other crime in which an individual loses their life could be equated to being as serious or grave as genocide. The whole edifice of the Convention stands upon the foundation of just how important and separate and standalone enforced disappearance is as a crime. That has to be duly recognised. I think it's a point that has been well made by Suela. I just wanted to add to our arguments, to draw your attention to the points that she made, and to underscore the importance that you live up to your obligation. It is a conventional obligation to adopt an autonomous crime of enforced disappearance in your domestic law. Thank you very much. Thank you very much. I give the floor next to Mr. Juan Pablo Alban Alencastro. Thank you, Chair. And I would also like to take this opportunity to bid a very warm welcome to the delegation of the Kingdom of Cambodia. Thank you for participating in this constructive dialogue. I have 3 questions, or 3 points, building on issues already flagged by our 2 country rapporteurs, Ms. Yanina and Ms. Lochbihler. And one of the points that I have has also been flagged by our colleague Ms. Vida Quintana. I think that reflects the importance of these issues, and that's why I'm going to ask my questions nonetheless. My first question pertains to this failure to have a definition of an autonomous crime of enforced disappearance. And so I'd like to ask how in practice, if you don't have a specific crime, then how do you provide a legal framework? If you have cases involving the elements, the facts that would feed into a case of enforced disappearance, how would you argue such a case, particularly bearing in mind that the Cambodian legal system is based to a large extent on the French legal system? How do you plug that legal vacuum? My second question is in response to one of the answers we've already heard, because His Excellency said that judges have a certain degree of jurisdiction or maneuver when it comes to applying aggravating or exacerbating circumstances. They have a certain degree of discretionality. And I'd like to have a greater definition of this idea of discretionality. What can the judge do? Do they have a free rein? Can they decide what elements of the law to apply, what facts to investigate? You say that this is provided for under Articles 93 and 94 of the Criminal Code, this discretion of judges, but I'd like to know what its limits are. Finally, questions have been asked about the statute of limitations, both in the questions asked by our country rapporteurs, but also by other colleagues as well. The point I would like to flag is in those cases where there is no accusation, but we are confronted with a situation of enforced disappearance, and 15 years have elapsed, would that result in de facto impunity? Or do you have a channel, an option in those circumstances where after 15 years have elapsed, you can take steps to ensure that there is no impunity for the fact that disappearance has occurred, no actual case has been lodged, no accusation has been levelled against an individual, 15 years have elapsed. Is there a mechanism for ensuring that should facts come to light, should somebody be apprehended, should the perpetrator of an enforced disappearance be identified, will they get off scot-free, essentially? Will they enjoy impunity, or other mechanisms to make sure that an investigation can go ahead even though the statute of limitations has elapsed? Thank you very much. There are just 2 minutes in hand. I'll give an additional 2 minutes, and that will give us the time to give the floor to Mr. Horacio Ravena.
Gracias.
Thank you, Chair. First and foremost, greetings to the delegation. My question will reiterate some of the questions asked by my colleagues, but I am curious and I welcome any additional information that you can share to respond to the questions asked by my colleague, questions that I shall now complement with my own questions, particularly the questions about the lack of a definition of enforced disappearance as an autonomous crime. if it's not understood as an autonomous crime, when an enforced disappearance does occur, then you can end up bogged down in trying to prosecute it through a raft of different crimes or criminal definitions, which is why it's so important to have this autonomous crime, and was one of the concerns that gave rise to the International Convention for the Protection of All Persons from Enforced Disappearance, to ensure that the seriousness and gravity of the crime could not be diluted in any way by treating it like another crime. Now, the stance of the delegation seems to be, if I've understood things correctly, is that they're aware that discussions have taken place in the United Nations, and that many state parties have asserted the argument that the existing human rights conventions mean that there is no need to have a separate convention which deals with enforced disappearance as an autonomous crime. It's dealt with by the other human rights conventions. To respond to that argument, I would suggest that you look at the work of the previous rapporteur on enforced disappearances, because the work that that individual produced went a long way towards arguing in favor of this separate international convention. The jurisprudence, the work, the academic work on enforced disappearance, a report put together by the rapporteur, Manfred Novak, is, I think, critical in understanding why it's so important for enforced disappearance to be understood as an autonomous or standalone crime. And so I think reading the work of Mr. Novak would be vital to help understand why there is so much pinned on ensuring that enforced disappearance is understood as an autonomous crime, and why this committee is so anxious to ensure that in the legislation of states parties there is specific legislation and specific definition of enforced disappearance as an autonomous crime. On this idea of a continuous or continuing crime, the possibility that there be no statute of limitations, and that and the way that this is handled in Cambodia, I think, gives us the concern that this is not understood as a continuous crime, because a continuous crime or continuous offence cannot be subject to the statute of limitations until such time as there is a response to the enforced disappearance. In other words, that it has been duly investigated and the fate and whereabouts of the disappeared person have been identified. Thank you. Thank you very much.
Thank you. Thank you very much to all colleagues for those questions. I'd now like to turn back to the delegation. There were lots of very specific questions and concerns which were very concrete. Obviously, there's 30 minutes left. We'd be very grateful if you could look at how to focus your answers on concrete cases in your responses. My colleague, Madame Lochbihler, just mentioned 4 cases recorded in the urgent action procedure. 2 of those cases are still in the pipeline, so we won't touch on them here. 2 of them, though, are closed because the circumstances, or at least the location of the individuals, was determined. And so it would be good to know in those cases what steps have been taken in terms of prosecution and inquiry, criminal investigation, all of those specific questions put by my colleagues. It would be very good to have specific answers in that regard. So I'll pass with that the floor back to you for 30 minutes.